Welcome to another episode of Patently Clear with Graham Archer. And in this episode, we're going to be tackling a big question that comes up a lot. How does patent infringement actually work? So how do you know if you're infringing someone else's patent or if someone is infringing yours?
Yeah, and before we dive in, a quick disclaimer. This isn't legal advice. What I'll share is an overview of the process a patent attorney goes through to figure out whether there's infringement. If you're making business decisions, always get proper legal advice.
Got it. Okay, so let's start simple. In principle, how does infringement get decided?
In principle, it's quite straightforward. You look at the independent claims in the granted patent. Independent claims are the ones that don't refer back to another claim. So claim 1 is always independent, but there can be others too. Then you compare those claims with your product or process. If your product or process includes all of the features or steps of any one independent claim, then you infringe that patent.
So it's almost like a checklist. If all the boxes are ticked, then you're infringing.
Exactly. If your product clearly misses a feature listed in the independent claim, you don't infringe that claim. On the flip side, if all the features line up, then you do infringe. In straightforward cases, that analysis can be very clear-cut.
Okay, but I imagine it's not always that clean.
You're right. Quite often, it's murky. For example, say your product has a feature that isn't exactly the same as what's in the claim, but it essentially works in the same way. That's where something called the doctrine of equivalent comes in, or less glamorously, the protocol on the interpretation of Article 69 of the European Patent Convention. In those cases, you need a patent attorney to work through the specific questions that determine whether your feature is considered equivalent and therefore infringing.
Okay, so even if you don't tick every box, you could still be infringing because of how it functions.
Exactly. And there's another wrinkle, indirect infringement. Say you're supplying part of a patented product, knowing full well that customers will buy the rest elsewhere and assemble the whole thing. Even though you're not selling the complete product, you could still be infringing indirectly.
Right, now that's a really important distinction. So you mentioned granted patents. How does that differ from pending applications?
Yeah, good question. You can't actually bring a court case on the basis of a pending application. A patent has to be granted before you can start legal action. But that doesn't mean pending applications are irrelevant. If the application eventually gets granted, the patent owner can sometimes claim damages for infringement that happened in the period before grant.
Right, so you could be at risk even before the patent is officially granted.
Yes, that's why it's important to know whether you're looking at a granted patent or just an application. And you can tell this by looking at the publication number. If it ends with an A, that's the published application while it was still pending. If it ends with a B, that's the granted patent. And once a patent is granted, the A version still exists, but always check the B version if it is available, because the claims often change between application and grant.
Right, so to kind of sum it up, the infringement comes down to comparing your product or your process against the independent claims of a patent. If every feature's there, then that's infringement. But even if every feature isn't there, there are situations like equivalent or indirect infringement where you could still be in trouble.
Exactly. It's simple in principle, but the details can get very complex very quickly, which is why it's always worth getting a patent attorney involved before making decisions around potential infringement.
That's good advice. Thanks, Graham.